Welcome to Professor Ortlieb's Blue Book Podcast, a series of podcasts designed to teach 1L students the basics of legal citation using the Blue Book. Previously, we've explored case citation, abbreviating case names, abbreviating reporter names, and providing both date and jurisdiction parentheticals as well as explanatory parentheticals. In this podcast, we're going to look at providing prior and subsequent case history under Blue Book Rule 10.7. You can find a corresponding rule in Blue Pages 10.1.6. We will also be looking at Table T8. Subsequent history can be found in Blue Book Rule 10.7. Subsequent history equals what happened on appeal. In other words, what happened to your case after this court decided it. Generally, you're only going to provide subsequent history when you provide a full cite, so only the first time that you cite a case. Table T8 is what we're going to use to find the introductory explanatory phrases that we will use before typing in our subsequent history. Subsequent history is always printed in your citation after the prior history. Here's an example of what a case might look like with subsequent history. You'll see that you have the regular citation of Hercules v. Hades, cited from the Illinois Appellate Court in 2015. Subsequent history is simply appended to the end of that citation, separated by a comma, introduced by an explanatory phrase found in T8, and the full cite of the new case follows. Let's dive a little bit deeper into subsequent history. Under Rule 10.7, generally you're going to need to include any subsequent history of the case that you've cited. A few things we're going to omit include denials of discretionary appeals, unless the decision is less than 2 years old, or the denial of the discretionary appeal is otherwise important. This might also be, you can think of this as denials of cert or denials of petitions for leave to appeal in the Illinois system. You're also going to omit remand or denial of rehearing decisions that come after your original decision, unless it's relevant to the point for which you're citing. Finally, make sure that you omit any disposition that's withdrawn by the deciding authority. Sometimes on rehearing, the appellate court or Supreme Court might withdraw its earlier opinion. If that has happened to your case, then you will not be citing that withdrawn disposition in your subsequent history. In addition to subsequent history, you might need to provide the prior history of the case that you're citing, but generally, it's not something that we include in our cites. We're only going to use it if it's significant to the point that you're trying to make, or where the case you're citing does not intelligibly describe the issues in the case. This is going to happen with Supreme Court memorandum decisions. It will also happen where the opinion that you're citing incorporates by reference a different court's opinion. This can generally happen around the statement of facts from a case, where the subsequent case just decides not to include all the facts because they were decided or at least discussed thoroughly in the earlier opinion. As I said earlier, your prior or subsequent history is going to be introduced by an explanatory phrase after your full cite. They're introduced by an explanatory phrase from T8. Here's a picture of what you can find in T8 in the Blue Book. You'll notice that these are abbreviations of a lot of the words that you've seen before. Affirmed, affirming, cert stands for certiorari. Reversed is abbreviated rev, apostrophe D. Whatever the subsequent history of your case is, you'll want to consult T8 to figure out which phrase to use when introducing it. Note also that each individual explanatory phrase has its own special punctuation. It's actually grammatical punctuation. So where necessary, we're going to include a comma. Don't worry, you don't have to think about the grammar in this. You just need to use the appropriate punctuation listed in the abbreviation. Note in my example that your explanatory phrase is going to be underlined or italicized, and in my example, I've underlined it so that it matches what I did with my case name. In the examples in T8, you will see that they're all italicized. So if you were typing this in your memo, you might want to, if you're italicizing your case name in your citation, you would also italicize your explanatory phrase. If you underline your case names, then underline your explanatory phrase. When putting together your prior or subsequent history, notice that your jurisdiction, court, and date parenthetical might be different. In this example of Robb v. Roy from the Northern District of Illinois, you'll notice that my original case, the first case listed, is the one that I'm citing to, but my parenthetical doesn't contain the date of decision. Instead, it's in the second parenthetical that says Seventh Circuit. I did this because both decisions, the decision from the Northern District of Illinois, as well as the subsequent decision from the Seventh Circuit, all were made in 1975. So where the dates of both the original case and the subsequent history are the same, we're just going to put the date in the subsequent history. Sometimes our subsequent history might have subsequent history as well. When that happens, and you must include both pieces of subsequent history, you're going to do so with a new introduction. So in this example, you see Robb v. Roy was decided by the Northern District of Illinois and then was reversed by the Seventh Circuit, which was then reversed by the U.S. Supreme Court, which basically reinstates the first opinion from the Northern District of Illinois. I introduced both of those subsequent histories with reversed, as indicated in T8. Note also here that that U.S. Supreme Court decision came down in 1978, so I had to put in a new date parenthetical to indicate the correct year of decision. Remember, there's no court listed or jurisdiction listed for a U.S. Supreme Court case within that date and jurisdiction parenthetical. Explanatory phrases do require us to give the prior history before the subsequent history. So, reversing things around, instead of citing to the Northern District of Illinois' opinion in Robb v. Roy, maybe I wanted to cite the Seventh Circuit's opinion. Well, if that's the case, I'm going to put that first and then list the prior history of that original Northern District of Illinois case. Note, I also then put the subsequent history from our last example after the prior history. So I noted that U.S. Supreme Court case last. Prior always comes before subsequent history. Always cite to the opinion you're referring to in the text first. And note that subsequent history can include a couple other dispositions other than reversed, including being overruled, abrogated, or superseded by statute. What does this mean? It means that sometimes a different case can be the subsequent history of the case that you want to cite. Let's dive into that a little bit further. First, let's talk about overruled cases. An overruled case is where a later decision by the same court explicitly repudiates or denies an earlier decision. In this example, I wanted to cite the case Good v. Hug. It was a case decided in Illinois in 1840. Subsequent to that, in 1940, Thud v. Bang overruled the law in Good v. Hug. I introduce it with overruled by. If overruled by multiple subsequent decisions, you'll have to add others to the cite with an and. Another type of subsequent history that may occur with a different case than the one you're cited is when you have a case that has been abrogated. A case that has been abrogated means that the case is effectively, but not explicitly, overruled or departed from by a later decision of the same court. When indicating a case has been abrogated by a subsequent case, the introductory phrase will be abrogated by. Again, all of these are available in T8. Another type of subsequent history that might happen to your case through a different case or through a statute is called superseded. Generally, this is going to be where a legislature subsequently enacts legislation with the specific intent of reversing the original case. Such history is indicated by superseded by. When a case is superseded by statute, you must then include the cite to the statute by the session law and statutes at large right after that superseded by explanatory phrase. You may, but you do not have to, cite a subsequent case that recognizes that the original case was superseded by statute. To do this, after providing the statutory cite that superseded your original case, you would have yet another additional explanatory phrase, as recognized in, followed by the case cite that recognized the superseding statute. Sometimes a case will have multiple dispositions. A case with multiple dispositions must be connected to the original cite. So in this particular case, in this particular example, we have Robb v. Roy, decided in 1975 by the Northern District of Illinois. That's the case I actually cited. My subsequent history showed that it was reversed on appeal by the Seventh Circuit at 567 F2D 75. There was then subsequent history to that, meaning the Seventh Circuit went back and modified its original opinion, and I could find that new modified opinion at 567 F2D 890. So here I indicated that that original Seventh Circuit opinion was modified. Now note here in the date, jurisdiction, and court parentheticals, the dates have shifted around. Here I'm showing you what happens when the original case was decided in 1 year, and then the subsequent history happened in subsequent years. So according to this cite, I can read and find the original case was in 1975. The first and second Seventh Circuit opinions on this case happened in 1977. When a parenthetical lacks a date, always look to the next date court parenthetical to determine the date that applied to the case without the date in the parenthetical. So 1977 here refers to the other Seventh Circuit case as well, not the 1975 Northern District of Illinois case. The 1975 does not carry forward. Sometimes when a case is on appeal, the case name may change, maybe because parties have changed, maybe because other parties were added in or other parties dropped out, but sometimes a case name will change. Generally, you're not going to indicate a changed name in the case when the party names are merely reversed, meaning plaintiff versus defendant becomes defendant versus plaintiff because the defendant is the one who launched the appeal. So where the party names are merely reversed in order at any level of court, that doesn't count as a name change that you must account for in your cite. Name change occurs in connection with the denial of rehearing or discretionary appeal. Those name changes do not need to be included as well. If it's an appeal of an administrative decision and the private party has not changed, you don't need to worry about noting a changed name in the case. We also don't need to note name changes when any change in name is merely stylistic. So where there is a new name that doesn't fit into one of those four categories, we're going to give the new name introduced by the introductory phrase sub nom. This comes after any other explanatory phrase, like reversed. So in this final example I've provided you here, Robb v. Roy, our Northern District of Illinois case that we've been playing with, changed on appeal to Roy v. Rogers. That didn't fit any of the other categories for not including a name change. So I had to put in sub nom after my reversed and put in Roy v. Rogers, the new case name. Note, there is no underline in the space between reversed and sub nom. There's also no underline in the space between an explanatory phrase and the subsequent case name. So make sure you're turning that off when you're formatting your cites. You've now completed the lesson on explanatory phrases for prior and subsequent history and are ready to work on your homework. If you have any other questions, please see me or a teaching assistant.